Today I'm joined by Sinal Govender, who is a lawyer and the co-founder of POP.law. And we're chatting about POPI, which has just come into effect in July. But in actual fact, it's been a rather lengthy process that started in 2013. What exactly is the purpose of the POPI Act?
Well, your guess is as good as mine at this stage. Like you said, this has been a piece of legislation or, the written piece of law that's been around for a number of years. And originally when it came out, it was to address this global problem of the abuse of personal information. So there's the likes of Facebook and Google and Apple who collect an extraordinary amount of data. But there was a worldwide movement to say we need to deal with this a bit better. So South Africa's response was to draft the POPI Act, which stands for the Protection of Personal Information Act. And you might have heard it being referred to as POPIA or the privacy legislation. But the wheels of change in the legal world turn very slowly. So that's why by the time it's come into force now, last month, it's kind of already been outdated. But I think that the biggest misconception is people suddenly think that this is a brand new piece of law that everybody's scrambling to comply with. But that's not really the case. We have our constitution, which goes back to 1993, the interim constitution, and then 1996. So the right to privacy has always been around in South Africa in some shape or form. And now this is just a way of trying to regulate it a bit more clearly. But that said, the POPI Act provides, some sort of framework, but it's not very clear. And because it's still a very new piece of law, we haven't seen yet how the information regulator, who's kind of the, head boy, head girl of privacy, will deal with it. And then also how the courts will interpret pieces of that law. So we're still a very long way away from having absolute clarity on what it's trying to achieve.
When it comes to personal information, let's unpack that a little bit for the purposes of the POPI Act. And I know you've just said it's not clear-cut, but can we give our audience a few working examples?
Sure. So the Protection of Personal Information Act, like all pieces of legislation, has a long list of definitions. And they are helpful to a certain extent, but especially when it comes to personal information, it's phrased very broadly, in the sense that it's any information that could be used to identify a person. But then again, we look at who a person is, and they talk about a natural person and a juristic person, which basically means individuals like you and I, and then corporate entities. So technically, in terms of POPI, we might have companies that could say, this is our personal information, and there's certain criteria that it needs to be dealt with. This is not really something that we see around the world in other pieces of privacy legislation. So we'll see how that is interpreted by our courts in the appropriate forums. But if we just go back to personal information, they do what lawyers love to do, which they put a definition down and then they say including. So it's not limited to this, but it could be things like your name, your email address, your phone number, and then it becomes a bit more abstract as well. So it could be things like your biometric information. It could be things like your IP address when you surf the internet. It could be passwords and logins. So it's a very broad category. And even though there's a few things that are quite obvious that are mentioned in the Act, I think the appropriate thing is to look at it from a practical point of view and say, is this piece of information able to be traced back to a person? And if it is, then it's considered personal information.
Correct. And I mean, we're in the digital age of connectedness, so it's crucial that all of these aspects are considered. I mean, so often you'll either get a phone call of somebody offering you something or an email, and it sparks the question of, how did this person actually get my information? I did not sign up for this. Now, specifically to the area of real estate and estate agents, can we distinguish what would be legal and illegal data processing?
Sure. What the POPI Act says, and I think that this is where a lot of confusion has also come into, it's not to say that processing or using personal information is unlawful. There are certain categories where it will be lawful, and one of those categories is where you have consent to use a person's information. But we need to unpack that a little bit more and say that consent needs to be something that's very specific, and it also needs to be something that's been voluntarily given. So if we look at a situation like you mentioned, where you're getting a phone call from a marketing agent and trying to sell you an insurance product, and you think, but hang on, how did they get my information? And it might be that there was a telephone service provider that has a nice book of phone numbers, and they could sell that. It became quite a marketable thing to do, to sell information. And we've had like the Consumer Protection Act, and there was a Direct Marketing Association that tried to stop that. But now what POPI does is it makes it fairly clear. So if I purchase a house, for example, and I have to deal with estate agents, it makes sense that they would need certain personal information in order to do their job. And the easiest way would be for me to consent for them to use that information. And then they would go through that, and also maybe share that information with the deeds office, because there's a legal requirement for them to exchange that information. But if I have given them my name, phone number, and email address, and actually my physical address too, those are all aspects of personal information that I would have provided for a specific purpose, for the purpose of selling a house or buying a house or renting a property. If they then use that to call me and to contact me, and to say, would you be interested in joining this, community newsletter, or, put differently, they would pass that information on to a completely different third party, and then they would contact me to say, we got your contact details from so and so, and we want to sell you our product. That is not okay. So we need to go back to what the original purpose was, and to say, are we still doing this in line with that? So for example, phoning somebody and say, we just wanted to check, it's been a couple of months, and have you settled into your new property? That should be okay. But the moment you start going broader and broader and broader, the more risk you expose yourself to. And not just that, but the POPI Act also makes it very clear that if somebody is an existing customer of yours, you can contact them to offer them similar services and products. But if they're not a customer of yours, you have to get consent from them, and you can only ask for that consent once. So my flat has currently got some tenants into it, and I previously was on the market to sell it and listed it on certain websites through an agent. But what I've found is that so many other agents have seen that property and are able to go onto the deeds registry or certain databases and get my cell phone number. And I get calls all the time from them to say, are you still interested in selling your property? Would you like us to do a valuation? And things like that. Behavior like that is not going to be allowed once POPI is actually in force, and people need to comply with it.
Okay, that's very interesting to note. So you've mentioned the deeds office. As far as I understand, that degree of information is public record. When is the use of it, in contravention of POPI?
So there's no difference really in terms of whether something is in public record or not. I think that there's this idea as well that if something is available on the internet, like you mentioned, we're living in the digital age, that it's a free-for-all. And that's not necessarily the case. I mean, personal information aside, there's other aspects like somebody's intellectual property rights that you can't just go around abusing. So what POPI does say, though, is consent is one way to comply with your obligations, but processing of certain personal information will need to take place for people to fulfill a contractual obligation or a legal obligation, and in which case that consent might not necessarily be necessary. So it's also about understanding, never mind what your obligations are in terms of POPI, it's about what information are you using and why are you doing that, and then looking to say, is this allowed or not allowed?
Okay, that makes complete sense. So it's always crucial to cross-check yourself as to, why do I have this information? Am I fulfilling exactly what I said I would when I obtained the information? And then that brings us to storage of information. Can you talk us through a few key aspects? Obviously, in the real estate industry, people are collecting information. They're fulfilling the specific service, but then how long are they allowed to keep that? They have to disclose in their terms and conditions what they will be doing, post conclusion of the contractual obligation. Could you just talk us through that?
I think the real estate industry is definitely going to be one that needs to change quite significantly with this, along with medical industries, insurance industries, any industry that is collecting a lot of personal information, because most people don't even know what information they have. And that is really the biggest risk. So understandably, there's been a lot of talk about you need a privacy policy and you need this and you need that, you need whatever. And that's all very useful, but it's only one part of your compliance. Something that any business, real estate or otherwise, needs to do is to first sit down and say, what do we have? And this could be physical documents that are stored in a locker cabinet. You start realizing, oh dear, we've got a lot of information here. The second thing is to look at is to say, the information that we have, do we need to be having it? Because the larger the volume of information, the risk increases exponentially. So, for example, if you're a real estate agent and you have sold properties over the last 20 years, it's highly unlikely that those properties and the owners that are related to that are still on your system or should be on your system. So even if there's paperwork, there's other aspects where you can either, from a safety point of view, keep it in the cloud or have it in a safer space so that it's less likely to be abused. And then the second thing is to then, once you've gotten rid of the stuff that you don't need, look at the existing one, the existing information that you have and say, right, do we need all of this information? Do we need something that always irritates me is when people, if you, for example, sign up to public Wi-Fi and sometimes they ask you, what is your gender? And that always irritates me because I think, does it actually matter? Why would I need to disclose my gender for somebody to provide Wi-Fi services to me in a public space? And it might be because they're trying to profile you or, send you some targeted advertising. So it's the same as any going to the dentist, going to the doctor, going to a real estate agent, even looking at the forms that you have and the processes that you currently do, really interrogate that and say, do I need to be collecting all of this information, or is it only information that is really necessary for us to do our jobs? And then start putting in proper internal processes. And that's where things like a privacy policy come in place. But a privacy policy for your customers is just as important as an internal data retention policy, which is basically saying, are we training our employees to know their responsibilities when they chat to people on the phone, when they send them emails, when they send information to a third party? Do they also understand the consequences of us not following the rules? And also, do they know what to do if something goes wrong? What are the channels to follow? So in a nutshell, it's not just a tick box exercise, and it's not just something that you can, put to one person in your organization and say, you deal with this. It has to be something that the whole company buys into, and that everybody is understanding why we need to be doing this. So it doesn't become a thing of, this is the law and we need to follow it. It's like, actually, this is the best way to run a business, and we can just minimize all our risks if we just follow these processes.
I think you've summed it up by saying it's about minimizing risk, that you're taking ownership or you're taking responsibility for this personal information being shared with you and managing it in a responsible way, and that your entire staff complement is aware of the processes and what's happening. Am I correct in saying that compliance will only have penalties associated with it in a year's time? Can you just wrap it all up for us in that regard?
Yeah, so when POPI was first written, it was always envisioned that when it came into effect, everybody would get a year, so 12 months to comply with the law. And obviously, a lot of people have been speaking about this for a long time and saying, don't wait until that year starts ticking, because it seems like a long time. But when you're trying to run a business and you're dealing with a million other things, I don't think it's realistic that you're going to take, X couple of months and focus on this exclusively. So there was this talk about saying, try get some things going beforehand. And we actually thought that POPI was going to come into force on the 1st of April. But then, as you know, COVID happened and things got pushed forward. And to be honest, I was a bit surprised that it then was prioritized before the end of next year. So when it came into force last month, I think a lot of people got a bit of a shock because, as you said, it now means that the clock is ticking and there's 12 months just to get your ducks in a row, notwithstanding everything else that's going on. And this idea of getting your ducks in a row within the next 12 months also, I think, needs to just be clarified a little bit, in that POPI does not require 150% compliance. You cannot make any mistakes. You're going to be penalized. What businesses will need to do is put themselves in a position so that when they are standing in front of the information regulator because somebody has made a complaint against them or there's been a breach of data, that they can say, we did everything that was reasonably expected of us. So we weren't negligent, we weren't reckless, we really took positive steps. Here's our internal policies, here's how we dealt with this is our communication with our customers. So I think it can be really overwhelming, but I think what the first step needs to be is just to take a step back, take a deep breath, and just take it one step at a time to make sure that in a year's time you can be fairly confident that you have done everything that can be reasonably expected of you. And as I mentioned, there's a lot of stuff that people can do on their own. So things like a data analysis of what information you have and why you're keeping it and those sorts of things, you definitely can start the process yourself. And then if you need a bit of help, then reach out. And if you need help with drafting documents or drafting internal policies, by all means, that's where you can reach out and get some expert help. But it's definitely not necessary to panic, and it's definitely not necessary to feel overwhelmed, because a lot of the stuff you can start today and actually start getting your ducks in a row.
Great. I'm so glad we've kickstarted this conversation, and I'm excited to see how POP law progresses. Thanks so much for joining me, Sinal.
Thank you for having me.